Welcome to Nuts and Bolts of Arbitration, Commercial Arbitration. I'm Belinda McCauley, Executive Director and CEO of the Beverly Hills Bar Association. I'm delighted to be here today to introduce our speakers, Aaron Gothelf and David Coher. Aaron is Vice President of the American Arbitration Association's Commercial Division for the Pacific region, overseeing California, Oregon, Washington, and Alaska. He serves as the National Chair of AAA's Entertainment Dispute Resolution Advisory Council and the Western U.S. Chair for their Healthcare Dispute Resolution Advisory Council. Prior to joining AAA, he was the Northern California Regional Director for Judicate West. David is a mediator and arbitrator at Coher ADR with extensive experience in legal practice, corporate counsel, and legislative service. He's held key roles at Southern California Edison, Irvin, Cohen, and Jessup, our across-the-street neighbors, and as legislative counsel to a U.S. congressman. David also serves as an ADR panelist for the U.S. District Court, Central District of California, and has held numerous civic leadership positions, including chairing the Pasadena Board of Zoning Appeals. And now let's get started learning all about commercial arbitration.
Okay, thank you so much, Belinda. I'm going to share my screen here. And David, let me know when you see it up.
It's up. You're ready to go.
Okay,
And
very good.
Thanks, Belinda, for the introduction.
Yep, appreciate it. All right, well, everybody, welcome to the Nuts and Bolts of Commercial Arbitration. I'm glad you're spending the afternoon with us here. A little bit about the program before we get started. This is a program that's going to take you kind of everything from the filing of the demand all the way to the issuance of the award. And it's going to be best probably for attorneys that are maybe a little bit more junior in their career that have actually never gone through a full-scale arbitration, or just folks that are looking to kind of brush up on their skills and understand the process. This is part of a series of programs we're going to be doing with the Beverly Hills Bar Association. Today we're going to discuss commercial arbitration, but we have upcoming programs for education and construction that'll be a little bit later into 2026. So without further ado, let's advance to the first slide here. So basically, it all starts with the arbitration clause. And today we're not going to be, we're not selling a product or a service here, so I'm not going to focus on necessarily any one provider. But pretty much the process is very similar between lots of the different providers. And it starts with an arbitration clause. Arbitration clauses are the way cases end up in arbitration. And I always like to say that the 5 parts of the arbitration clause that are most important are the rules to be used, the location of the arbitration, sometimes referred to as a seat of the arbitration, whether it's going to be heard by a single arbitrator or a panel of arbitrators, and the governing law of the arbitration, not just substantive but also procedural law. In California, we have the California Arbitration Act, and then lastly, if there's some sort of cost shifting provision where the uh, winning side's entitled to recover attorney's fees, arbitration costs, etc. And you want to be very specific about what constitutes attorney's fees, arbitration costs, etc. Oftentimes, it's just attorney's fees that might be recoverable. Sometimes it's the cost of the entire arbitration. And so the more clear you can be in an arbitration provision, the easier the arbitrator will have understanding exactly what authority they have. And I just, on this slide here, drafted a very basic arbitration provision here that covers all the 5 things that I mentioned. And so just in the materials here, it's something to take a look at.
Yeah, and I'll just note on this, what Aaron has here is basic, but it's also thorough. I find in practice that unfortunately arbitration clauses are not always as thorough. They will leave key pieces out, and it's important that you bring those issues up early on in the arbitration and get those sorted out before the issues they present come full throttle into the hearing.
And the reason I chose those 5 elements that are the most important parts of an arbitration provision, because realistically, you could put dozens or hundreds of different things into an arbitration provision, but those 5 things tend to be the things that are the most commonly fought about. And then when there is an issue or a disagreement as far as what the arbitration clause says, oftentimes it has to go to somebody like David to kind of interpret it. Or in a worst case situation, the parties don't even want to start the arbitration. They want to go straight to court. They're going to file a TRO to start the arbitration. They're going to ask a judge to sort out in this 100+ page contract, why buried on page 87, clause 2A, there's a three word arbitration provision or a one-sentence arbitration provision that makes absolutely no sense, right? So if you're going to spend all that time drafting that giant contract, spend a little time actually working on the arbitration provision. Okay. So this is basically the best kind of overall synopsis I can give you in a single graphic or a single slide, with start to finish what a commercial arbitration looks like. Not just commercial arbitration, but a lot of other arbitrations kind of follow the same pattern. And what I like about this chart is it also kind of gives you a rough estimate on the number of days kind of each step takes. Now, this is based off of a standard kind of large complex commercial case arbitration in the timeline attached here. And some people might say this seems like it takes a while. It's almost a year long, maybe this process. But we study kind of how long the federal district court takes in various state courts, county by county, take to get your case from filing to an actual jury verdict. And oftentimes it's 3 or 4 years. So the simple fact that arbitration can resolve most disputes in under a single year proves that arbitration is still a faster, usually more cost-effective way to resolve disputes than traditional arbitration. Again, filing and initiation, the first step, and I'll have individual slides in each of these. Arbitrator selection period, the preliminary hearing, which is the first time the parties actually get to interact with the arbitrator and set out the course for the rest of the process. And then you can see on my chart here, the period that takes the most amount of time seems to be the information exchange and discovery period. Now, discovery doesn't have to take so long if there aren't lots of discovery disputes, and we're going to talk about how to handle discovery disputes a little later on in the presentation. But discovery disputes do sometimes really gum up the process, if you will, and kind of lengthen it. The mediation step at AAA, we're really pro using mediation to resolve disputes. And if the parties can use mediation at some point during the arbitration process to resolve the dispute prior to the evidentiary hearing taking place, it's going to save the parties a lot of time and money. The hearing itself, the evidentiary hearing, which is like your trial, if you will. The post-hearing submission period, which would be post-hearing briefing, as well as briefing on attorneys' fees and costs if there's a prevailing party um, provision written to the arbitration provision. And then, of course, the award. And there's lots of different ways an award can be drafted. It can be as simple as a simple award. This is what the winning side gets, and this is, essentially why they get it. To a more reasoned award where it can be very many pages long, where you explain the decision-making process between each of the individual elements of the claim or claims. Okay. So filing and initiation, and I'm going to go over the first couple slides, and David's going to be a little bit more towards the end of the presentation, because then we're talking about the more substantive stuff that David gets involved with as an arbitrator. I'm an administrator, David's an arbitrator, so different roles here. So filing the submission and initiation. So the claimant basically submits their demand for arbitration, copy of the arbitration provision, which is in the contract between the parties, and the appropriate filing fee to AAA. It's really simple. And while you can file an arbitration just with these three elements, we usually prefer, and I'm sure David actually prefers, to get a full complaint drafted along with the demand for arbitration. Sometimes parties are trying to do their arbitrations relatively quick. And so they'll just fill out the demand for arbitration form, send in a copy of the contract with the arbitration provision highlighted, and pay the filing fee. But the demand for arbitration form is very basic. It just talks about fill in the blank who the parties are, who their counsel are, people's addresses, how much money you're seeking or whatever particular damages are, maybe possibly injunctive, and then basically a 2 or 3 sentence synopsis of what happened. That's not going to be enough information for David to process anything. So, David, you have anything to add to that?
Yeah, I'll say, I see. I don't know what the split is, but I see a good number of cases where it is just a simple demand form because people want to get the process started quickly, and then other cases where the demand is much more akin to a fully drafted complaint. If it is something where it's not that fully drafted complaint, then that's going to be one of the first issues that we discuss really after the items of the arbitration clause in the preliminary hearing, because we're going to have time allotted for that. And then, of course, for an answer from the respondent regarding what is in that later amended demand. But at the end of the day, there is going to be a need to specify what it is that, if you're the claimant side, what it is that you're looking for, what has been done wrong here, why that is wrong, before you can really get into the meat of the information exchange, so that there's some guardrails as to what information needs to be exchanged.
Yeah. All right, so the AAA acknowledges receipt to all the parties and sets a deadline for the respondent to answer or file a counterclaim. I would say the vast majority of uh, uh, answers filed don't initially include a counterclaim, but again, that's going to be something that David's going to discuss in his preliminary hearing call, where he essentially is going to ask, can I anticipate a counterclaim being filed? Because that's going to obviously add to the timeline to the process. It's also very important, steps 1 and 2 here. Um, Anytime anything's filed, so that initial demand for arbitration provision, and then the filing fee, um, that demand for arbitration needs to be served at the same time also on the respondent. So occasionally we get submission situations where the claimant forgot to serve simultaneously the demand, and sometimes the demand and complaint, on the respondent. So the first time the respondent even knows about the case is when we reach out to them to set up an administrative call. It shouldn't be like that. They should know that there's been a case filed against them. Um, so if no arbitration clause exists, or the AAA is not named as a resolution provider in the party's contract, it's a bit of a different process. So you use a different form called the submission to dispute resolution form. And essentially, if we're not named as the provider, or arbitration isn't named as the method of resolving the dispute, for us to handle the case, both parties have to agree in writing to proceed with AAA to administer the case. And that's what's on the submission dispute resolution form. There's a box that says all, and I shouldn't say both parties, I should say all parties, because sometimes there's more than 2 parties in an arbitration. But essentially, all parties would have to sign off on the form that they agree to proceed with AAA arbitration. Um, Again, typically the filing party submits a formal complaint and with the demand for arbitration, but not always. And it's very useful to David, because if he actually gets a formal complaint along with the demand for arbitration, he can read that and start studying that in advance of the preliminary hearing, so he might know what questions to ask you. It makes his life a lot easier as the arbitrator. Um, and this is a common source of confusion. If the respondent fails to, submit an answer by the AAA established deadline, um, their non-response is just treated as a general denial of all claims. You don't automatically win your arbitration just because the respondent never responded to your demand for arbitration or your claim. It's treated as a general denial of all claims, and sometimes the arbitrator at the preliminary hearing might actually say, like, I really could use an answer. It would help me with the process. David, do you ever ask one at the preliminary hearing if they haven't actually submitted one?
Yeah, it's sometimes at the preliminary hearing, sometimes that's at a follow-up hearing if it's a later submitted demand, but that's going to help minimize issues later on, right? Having that answer, having the explanation on file of why, as the respondent, your client did not do something wrong as alleged in the demand. I mean, that's really what it boils down to, is just telling that initial part of the story, and more so than necessarily trying to guide the presentation at the hearing, at the evidentiary hearing, or something like that. It's a helpful phase to help set the limits on what is going to be the subject of the arbitration, because even though it's arbitration, even though it's designed to be more efficient, there's a lot of emotions can run high, and that can mean that parties can get carried away. And so these limits on what is the subject of the dispute that's before me as an arbitrator is important for me to be able to provide those guardrails that are going to keep the proceeding efficient and keep it from turning into, a 3-4 year litigation affair.
Yeah. All right. So the next stage, so essentially once the arbitration has been filed, and assuming it's been filed properly, a case manager at AAA will reach out to the parties and set up a basic administrative call. And this administrative call is basically to make sure the parties are in agreement, if they are in agreement, on what the terms of the arbitration provision say, confirm location, confirm claim amounts, all that kind of stuff. And sometimes in the arbitration provision, it actually lists a fairly detailed process in how an arbitrator is going to be selected. For example, sometimes it might say the arbitrators are to be party-appointed arbitrators, right? And each side selects their own arbitrator, and the two arbitrators would select a neutral arbitrator. Sometimes it actually says the good old-fashioned rank and strike method. It might say a single arbitrator to be selected by the rank and strike method, and the AAA will put together a list of resumes that the case manager thinks are appropriate for the case, and the parties will do their ranking and striking. Um, Sometimes it's completely silent, and then when it's completely silent, the case manager basically says, "How do you want to go about selecting an arbitrator for the case?" If the parties are not in agreement on the process, then you usually have to default to the traditional rank and strike method. Um, so when you're discussing with the case manager, kind of what your or case administrator, what you're looking for in an arbitrator, I always like to say that the right arbitrator for your case is the arbitrator with the correct subject matter expertise. So every once in a while, I run into a situation where I'll get one party that says, "I don't care what the background of the arbitrator is. They just have to be a retired state or a federal judge." And I sometimes dig down a little deeper into that because I might say, this is a fairly complex IP dispute involving semiconductors. And are you telling me you'd rather have a judge that has no experience in the technology space and knows nothing about semiconductors, as opposed to, let's say, an attorney arbitrator that's practiced for 30 years at an AM Law 100 firm in the technology practice and has wrote the treatise on every single semiconductor book out there, right? So essentially, I really encourage people to, when they're selecting an arbitrator, say, you know what? I can move a little bit away from titles and things like that. Maybe it doesn't have to necessarily be a retired state or federal judge. I could go with a subject matter expert or an attorney arbitrator if I really feel like their experience is spot on, because that's going to give you the best result. Oftentimes, when an arbitrator is selected that does not have the correct experience to match the dispute, they are going to spend a lot more time trying to learn the law. And they're going to, because arbitrators charge hourly, they're going to be billing you all these extra hours to learn stuff that they should already know if they were an expert in the field. All right. So I say think beyond the rank and strike list. If you have a good working relationship with opposing counsel, why not select the arbitrator together? If you're getting along with opposing counsel, the best way to select an arbitrator is to ask the ADR provider or the case manager to say, "Hey, who do you think would be good for this?" You don't have to send the resumes in a formal rank and strike kind of format, but just send us a bunch of resumes and we're going to exchange those resumes with each other and kind of talk it out, right? Um, Absolutely use the ADR provider staff. We spend a lot of time putting together arbitrator lists. We know who's probably best for your dispute based on our experience. One thing I like to point out is sometimes an arbitrator may have the experience you're looking for, but because arbitrators can't have 10, 15, 20, 30 page long resumes, no one's going to read past page two. Um, the experience might not be listed on their resume. So if based on where they've practiced law or some of the subject matter you see in their resume, you think they might have the right expertise for your case, but you're not quite sure, just give the case manager a call. Say, "Hey, can you reach out to this arbitrator and ask them if they have experience with X, Y, and Z? Because we're considering bringing them on board." And lastly, and this is unfortunately not utilized enough, sometimes interviewing an arbitrator jointly, where all the parties get together and they ask the arbitrator questions about their experience arbitrating particular types of cases, is a really great way to get to know the arbitrator and really kind of look beyond just a paper resume and kind of into whether they'd be right for your case. Obviously, all parties have to be in the interview at the same time, so there's no ex parte communication. And it's also, this isn't the opportunity for you to start arguing the merits of your case. You're simply interviewing the arbitrator about their experience. Okay, and then I'm going to bring David in just a second to kind of discuss the process. But as David mentioned, or as I mentioned a little bit earlier, the first step is the preliminary hearing in the process. So the preliminary hearing is when the parties and the arbitrator actually come together. And the point of the preliminary hearing is to obviously set out the timeline for the case so the arbitrator can draft a scheduling order, but also to discuss any possible wrinkles or disruptions along the way that might be encountered. Everything from potential discovery disputes to now the respondent, which has already filed an answer, would like to file a counterclaim. Whether some sort of emergency relief or declaratory relief has to be made kind of right away within the case. Uh, and things that the arbitration provision might say. A lot of times arbitration provisions might have things like accelerator clauses in them and stuff like that, where it gives a certain timeline to complete the arbitration. Obviously, it's important to have the discussion with the arbitrator, what their timeline looks like to make sure everything can go along that timeline, or if an extension has to be asked for at that time. So you'd want to meet and confer with opposing counsel. And again, if it's more than two parties, all parties together, on at least two or three mutually convenient sets of final hearing dates. I understand that oftentimes respondents like to kick things out further than claimants because claimants are trying to get their award relatively soon, but it's always good to have a good number of dates. Um, you should always have a general idea of witness availability in addition to the hearing dates. That's going to be obviously very important if you're going to be presenting witnesses. Confidentiality and possible protective order requests. Sometimes protective orders are worked out after the preliminary hearing, but if they can be worked out beforehand and just ready for the arbitrator's signature, literally right at the preliminary hearing, that might be great, or even in advance. Cybersecurity issues. I should mention that David and I did a presentation actually um, on cybersecurity issues just yesterday. And David's a certified information security professional, so David knows all about this. And how electronically stored information will be transferred and stored. Obviously, what happens if information is inadvertently disclosed and what kind of clawback provisions will be worked in. And of course, the type of award you expect. For most large complex cases, I would say a reasoned award is to be expected. It doesn't have to be a 40 or 50 page long award, but it has to be enough pages for the parties to understand what happened. And you really want a reasoned award if you anticipate any enforcement actions, because it's very hard when you go to court and ask a judge to enforce an arbitration award against a non-paying party if it's just a simple award and the judge can't actually follow the timeline of the case or the reasoning behind the arbitrator's decision. Um, which states govern, which states' laws govern the choice of law provision? This is particularly important if you're dealing with parties in multiple states. Every party is going to say their state's laws govern, and that may not necessarily be true. Of course, if you had written into the arbitration provision in the first place, you wouldn't have this dispute. Procedural issues, are we going by the FAA, the CAA, which act are we going to use for procedural issues? Then lastly, are there any jurisdictional issues proceeding in arbitration? Occasionally on the preliminary hearing call, we're going to get one party that says, my client's not a party to this contract for X, Y, and Z reason. Therefore, the arbitration
Yeah.
provision doesn't apply to my contract. They shouldn't have to go through this arbitration. We want the arbitrator to make a determination on that. And somebody like David, through the AAA rules, is impaneled with the authority to rule on jurisdictional issues. Now, occasionally there's going to be somebody that's really, really upset that doesn't believe the law allows the arbitrator to make these decisions and wants to, again, run to court, file a TRO, get lots of people involved. Listen, anytime you go to court, whatever confidentiality provisions that kind of existed in arbitration, being a
Yeah.
confidential process, are completely out the window. Now it's all on the public court docket. And going to court, as you know, is very expensive and not very quickly. So, David, you want to add anything to this slide?
Yeah, so I'll say first off, regarding this slide, I think this is an excellent outline for either, ideally, a pre-preliminary hearing call with opposing counsel or counsels to review what are the issues that are going to need to be addressed by the arbitrator, and also to identify those issues so that you can bring them forward for the arbitrator to set an appropriate schedule for resolving, whether it's something regarding something as fundamental as a jurisdictional issue or a choice of law provision, which states laws apply, things of that nature. Oftentimes, these are issues that if you spend a little time working it through with opposing counsel, you can identify. I don't, as an arbitrator, expect you to come to the preliminary hearing with all these issues sorted out. Obviously, there's a dispute underlying this that it's not reasonable, But what is reasonable, I think, is that when there's a situation where you're able to work with opposing counsel to identify the issues, and that way you can both succinctly present, here's our brief view of the situation, then the other sides, any third parties or beyond. And then we can figure out what's needed to resolve those issues and what order to resolve them in an orderly fashion. Because the alternative is if you show up at the preliminary hearing and you haven't had that discussion, it's going to take longer to have the preliminary hearing. But for me, it's really key to get
Or I'll
these
point out
issues
just
sorted
the
out.
worst case
Yeah.
scenario, not to cut you off, is yes, it'll take longer to do the preliminary hearing. Or
Hmm.
worst case scenario is you have to do the preliminary hearing all over again, right? Because you didn't have
That's
enough
exactly right.
information even to do it. So go. Sorry, David.
That's no, that's exact, and that's exactly where I was going, Aaron. It can end in a situation where you're doing multiple iterations because if folks don't go through this list and be thorough at the preliminary hearing. And so I think this is a great list of items.
And again,
I,
again,
I
your clients want you to go
yeah.
through one preliminary hearing, not two. They want to pay for one, not two.
Exactly. We're in arbitration largely for efficiency, and to deliver that, that means having to think ahead and just plan, right, and be prepared.
All
So,
right. So I'll continue with other things to go over. Steps to take when you're meeting conferring before the preliminary hearing. Is the case proceeding under the correct rules? Oftentimes, unfortunately, and this happens with AAA clauses, jam clauses, etc., that
mhm.
it just says according to the American Arbitration Association rules. And that's not a lot of help because we've got commercial rules and construction rules and consumer rules and all sorts of different types of rules, right? And all the rules kind of handle things differently, right? So you want to confer with the other side to make sure they're in agreement on the type of rules, especially if the term commercial or construction or employment is like missing from the provision. Um, can the scope of the arbitration be narrowed? You'd be surprised how many issues can be resolved prior to an arbitration just by talking to the other side, including potentially the entire case itself. Some of these things might be misunderstandings and easily corrected. Um, are there any issues that can be resolved prior to the preliminary hearing? Again, if someone's submitting a complaint with 15 causes of action and you can knock off 5 of those causes of action just with some quick partial settlement or something like that, just, might make sense to do it at that juncture. Um, has an early neutral evaluation session take place, also known as an ENE? For those of you that don't know what an early neutral evaluation is, this would be somebody akin to a mediator coming in that's a subject matter expert in your particular type of dispute, and they're going to study your dispute for a little while, and they're going to basically give you their opinion on how this would shake out if it went to a full-blown arbitration award or if it went to trial or something like that, based on their experience and what they've reviewed. I don't think early neutral evaluations are utilized enough in litigation in America. I think early dispute resolution, particularly ENEs, are very useful. Um, will a counterclaim be filed? Again, it's going to change the timeline if one's going to be filed. And if you're the claimant and the respondent's filing a counterclaim, now it's going to change a little bit of your timeline in the sense that now you have to not only pursue your claim, but you have to defend your client against the counterclaim. So it's you should probably you need to prepare your client. It's going to be maybe a little bit more expensive and a little bit more involved than it was prior to the counterclaim being filed. Um, is a motion for summary disposition likely to be sought? So if there's going to be any type of dispositive motion, MSJ, whatnot, it's good to let the arbitrator know at the preliminary hearing so they can bake kind of that time into the timeline. Um, and additionally, it would be useful to know if the respondent, let's say, is planning to try to knock the entire case out with an MSJ or just certain causes of action or individual parts of a claim. Will there be subpoena requests and will those be challenged? Depositions, subpoena requests, challenging subpoena requests, arguing about how long depots should be and who should be deposed and all that are some of the most timely and costly discovery issues that have to be dealt with. So if they can be dealt with up front, that's going to save your client some time and money. If has a mediation been scheduled? If so, when? Oftentimes, and it's very refreshing to me when I get on administrative call with parties, even before an arbitrator has been selected, the parties let us know that there is a date for a mediation on schedule, and that should that mediation be successful, we can close the file on the arbitration. Sometimes they don't even want to go through the arbitrator selection process until the mediation is taking place to see if they can resolve it at that juncture. So again, very pro mediation here at AAA, and we want folks to be happy with the result of their case. And lastly, draft a proposed joint scheduling order if possible. Again, I know it's very hard, especially maybe if you don't have the arbitrator's full availability, to put in all of the discovery deadlines and counterclaim filing deadlines and MSJ deadlines and evidentiary hearing dates and things like that. But if you can kind of get a very rough outline to David of all this, David's going to do his
Mhm.
best to kind of work with what you've come up with. David, you want to add anything to that?
Yeah, no, I'll say, I mean, that's what makes me happiest in a preliminary. If I get an email before we get on the call, usually the day before, but nonetheless, where there's a joint scheduling order, and it doesn't even have to be that everybody has agreement on the dates. I have seen joint scheduling orders where the council were not, it wasn't the most friendly of relationships. But nonetheless, they understood that it made sense to lay out where they stood and what the choices were, and to put that into a cohesive document, which made my job much easier in that regard. Um, in terms of, so again, it's not necessarily that you're going to reach agreement on all of these issues. I understand that. I appreciate it. I appreciate that there are very real and sometimes deep differences, but the fact that you've thought it through is helpful for me as the arbitrator in knowing that we are on the right path.
Hmm.
And one last thing I want to add on to what Aaron said about discovery and that information exchange process. The motions practice around that can sometimes be the least efficient part of an arbitration. And because if you set up what it is that the case is about and what is the subject of the case early on, then you can really set those guardrails in place so that the whole proceeding can move along efficiently.
All right. All right. During the preliminary hearing, so discuss page limits on any briefing, and I always say this: any briefing in exhibits, right? Because we've all seen 5 page limits on like some sort of brief, and then they send in 300 pages of exhibits that they somehow expect the arbitrator to all read. So, um, let's include exhibits in that. And then discussing page limits on briefing can be done at any point during the process. It's basically the best thing to have an efficient process. Oh, if your legal secretary keeps your calendar, they need to be on the call with you, right? We get in these situations where the parties are arguing over dates, and they get into a situation where one side says, you know what? An attorney says, I can't decide. I can't tell you when I'm available for an evidentiary hearing because my legal secretary keeps my calendar and she's not here today or he's not here today. That's not very useful, right? You want to set the hearing within a reasonable time frame, even if dispositive motions have been planned. This is what I like to discuss here. It is very common to, especially, I'm beating up on respondents today, but I'm just trying to pick someone to beat up on, right? So it's very common on the preliminary hearing for uh, evidentiary hearing dates to kind of being discussed when they should be, and the respondent says, "I don't think it's appropriate today to discuss evidentiary hearing dates because I plan on filing a dispositive motion of some type, and
Mm.
I'm convinced that in totality my dispositive motion will be granted, and I'm going to get rid of this case." And I'd like to wait to
Mhm.
see what the ruling is on my dispositive motion before we discuss any dates. Well, now we
Mhm.
have to do the preliminary hearing kind of all over again, right? And we have to have a second one of these calls. So if you're going to file an MSJ, what makes the most sense is just kick the dates out for the evidentiary hearing a little bit, but get some dates on calendar and say, listen, I'm going to add some time into the timeline to get a ruling on your dispositive motion. And it's not going to impact the evidentiary hearing based on where I put it in the timeline. Um,
Yeah, and
yeah,
I'll say that when I'm dealing with a case, I'm going to lean very heavily on setting those dates from the start so that we all have that understanding. It's much easier to take dates off of calendars than it is to add them on
that's
later.
right.
And it's just going to
And,
extend
and
things
David,
out
your
further.
schedule is just going to get busier and busier as it goes on because you get more new
Not
cases
just mine,
coming added to your
councils,
schedule. Exactly. Right.
everybody's.
Yeah.
Yeah.
All right.
Yeah.
Discovery should be tailored to the dispute's complexity and issues. Now, I've just got to say this. The whole point of arbitration being a faster, more cost-effective way to resolve disputes is this is not general court style discovery where we can do 27 depots for $100,000 case, right? I mean, that's just absolutely ridiculous. There has to be some proportionality to things, right? So you need to be prepared at the preliminary hearing to argue for and against and set limits on certain types of discovery. Again, the depositions tend to be the most complicated. How many depots are we going to take? How many hours is each one going to last, et cetera, et cetera. Obviously, you want to identify issues capable of early resolution to narrow the scope of the hearing, and then of course set a reasonable deadline for filing dispositive motions. David absolutely likes nothing less than somebody filing an MSJ 2 days before the evidentiary hearing or something like that. And David won't even allow that because he's going to put a deadline for that MSJ well in advance of the evidentiary hearing.
Yeah.
Consider a joint stipulation of facts. One thing when David is discussing, what to do when there's a discovery dispute between the parties at the preliminary hearing and kind of setting up a procedure for dealing with discovery disputes, the first thing he's always going to say is the parties should meet and confer with each other and see if they can work it out on their own before they come to him asking for resolution. And he'll say if you can't resolve something, at the very least, I want to know what you can agree on. So you're going to have to present to me some sort of joint stipulation of facts. And then, of course, you want to set hearing limits in a mediation cutoff earlier in the process. Here's the thing. Well, I'd like to think every mediation is successful resolving the case the day of the mediation. We all know sometimes the parties need a couple of days, sometimes a couple of weeks after a mediation session to evaluate how that mediation session went and maybe pass back and forth a few more offers and counter offers and whatnot. So
Yeah.
you want to make sure the mediation takes place far enough in front of the evidentiary hearing so that it can be successful if it's going to resolve the case. And also you want to be mindful, many arbitrators have a cancellation period. Sometimes it's 14 days out, sometimes it's 30. Some arbitrators have a 60 or a 90-day cancellation window. There's absolutely nothing worse than settling a case prior to the evidentiary hearing and then finding out that you went 5 days into an arbitrator's cancellation period, and now you've got to pay for the entire evidentiary hearing or whatever their penalty is. All right. We're running a little bit behind, so I'm going to speed up the process a little bit. So,
Go ahead.
information exchange and discovery.
Yeah.
The parties work within the time frame set forth in the preliminary hearing to exchange information and prepare their presentations. That's pretty straightforward right there, right? And then, as I mentioned in the last slide, David or the arbitrator is going to set up a process for resolving any discovery disputes, or if you're at some sort of impasse or challenge. Again, discovery disputes are going to be sometimes the most costly and time-consuming part of the process, as David mentioned. So the parties should make every effort to meet and confer and resolve issues themselves. If the parties cannot reach a resolution, then they should figure out what they agree upon, produce that joint stipulation of facts, and you can even just have it on the same sheet, right? Basically, you can have one column that says we agree on the following issues. These are the issues that we disagree on. Then another sheet that says this is what party A thinks, this is what party B thinks, possibly what party C and D think if it's a really complicated matter. That's going to be useful to the arbitrator when they're deciding how they're going to go about resolving the discovery dispute. And remember, oftentimes these discovery disputes can be resolved with just basic briefing. You don't always have to have a full oral argument scheduled. Oral arguments add time to the process. People have to find time in their schedule to do them. A busy arbitrator might not have time to get your oral argument scheduled relatively quickly. So again, if it can be handled during the briefing, it should be handled during the briefing. David, you want to add anything to this slide?
Yeah, let me add on this that I've seen it happen regularly where just putting together the documentation of what each position is from the parties and combining that together, working on that joint document, that can end up causing for the parties to reach an agreement. Oftentimes, it's an extension of time. There's some narrowing of what's going to be exchanged, but the parties figure it out. One thing, I've been focusing on, look, there's going to be disagreements and whatnot, but one thing that's great about arbitration is at the end of the day, you can agree with the other party or parties to change virtually anything. Okay. So if you guys, while working it out, come up with a better solution for the discovery process, you can work together, present that to the arbitrator, and ask for a change of the schedule, ask for a change of most any piece of the arbitration, and usually the arbitrator is going to grant it, because again, we're here to help move this along efficiently. So you're working together and finding those points of agreement that can narrow the issues. That's what's going to help move things along.
And I'll just add to what David said. So it's a party-driven process, right? At least at AAA. So, the first thing we look to is the law, right? The law supersedes anything that happens with our rules or the process. But beyond the law, the second most important thing is what the parties want to do. So if the parties have some sort of process that, even if it conflicts with AAA's rules, um, if the parties are all in agreement and they stipulate to using whatever process they've created, 99% of the time the arbitrator is going to agree to it, and that's just fine. We usually only have to default to the AAA rules when the parties are not in agreement. Okay. Um, I just really quickly wanted to go over the slide here. Again, because discovery is so costly and takes a long time, at AAA we came up with a couple different options to try to make it go quicker or at least make it cost less money. And the single big best way to save money, especially if you have a three arbitrator panel, is to have simply one arbitrator appointed to handle all discovery issues. That can be the chair. It can be a wing that the chair has delegated the work to, whatnot. Um, and there's a couple of different options with streamlining an arbitration panel you can work with. Sometimes you're going to appoint all three arbitrators, and they'll all take part in the preliminary hearing, and the two wings kind of disappear in the background till we get to the evidentiary hearing. And let's say the chair handles all the discovery disputes up until the hearing. And then there are situations where you don't even appoint the two wing arbitrators. You just literally appoint a single arbitrator, the chair at this point, to handle everything. And if it goes to an evidentiary hearing, then at that point you can add on the wings. But these are both great ways to save money on discovery. All right. At AAA, and I believe other providers have a similar rule or kind of a process. For claims or counterclaims that exceed $100,000, we require the parties to make a good faith attempt at arbitration in advance of the evidentiary hearing to hopefully save them the time and cost of going through a full-blown evidentiary hearing, pre-hearing briefing, post-hearing briefing, attorney fee applications, paying the arbitrator to draft the award, et cetera, et cetera. Um, any party can unilaterally opt out of this, and it's always very sad when a party chooses to do that. But I think most parties, in my experience, are choosing to do some sort of mediation. Um, Obviously, I mentioned it saves considerable time and money. The arbitrator should set the deadline for the mediation to be completed in the initial scheduling order, and they should make sure that there's enough time in between when that mediation is scheduled and when the evidentiary hearing is scheduled, so that we're not running into anybody's cancellation periods and stuff like that, especially if the
Yeah.
case is not resolved the day of the mediation and the parties need some time to think after. Um,
Yeah.
Very important, and a common misconception here is that if I have a mediation on calendar, that somehow acts as a stay to the rest of the arbitration process, including delaying the arbitration hearing, evidentiary hearing dates. Mediation does not act as an automatic stay to the rest of the arbitration timeline that's been set forth in the initial scheduling order or a revised scheduling order. Um, so just something to be aware of. Um, I
Yeah, but I will say that it may not be an automatic stay, but it may be a very good reason for extending out the dates in the arbitration. And again, if that's something that the parties are agreeing upon, we want more time for mediation, you know, you're going to get that 9 times out of 10.
Exactly. So if both parties are in agreement, or all parties are in agreement to extend the evidentiary hearing dates or extend the process because they really think they want some time to work on the aftermath or the result of this mediation, then that's fine if that's what everybody agrees to do. All right, drafting effective hearing, pre-hearing filings and briefs. Obviously, you want to set the stage for your case. A succinct, strong preliminary statement's the best way to start out. And you want to set forth your expected proofs, obviously stuff that, evidence that you have, right? And don't overpromise in
Yeah.
any of the situations. It's also really important for both sides to learn from MSJs and other disposition rulings. You can learn a lot about your case, especially if you're on the losing end of an MSJ, potentially reading through what the arbitrator wrote about why you lost and how that might impact kind of the evidentiary hearing. Obviously, state the law, focus on key factual issues. When you're providing case sites, you're going to want to provide e-links, right? So the arbitrator can very quickly click on the link and read the case. And I think it's a good idea to have hard copies of key statutes and cases, just if you're going to put together a trial binder for the arbitrator and whatnot. I know, it's not the greenest thing to print so much stuff, and sometimes David might just ask for this to be in electronic form, and that's fine. But you should ask what the arbitrators are thinking about. Then, of course,
Yeah.
consider in limine motions as far as a process goes. David, do you have anything to add to this slide?
No, I'll just say, I mean, I've had situations, so I personally prefer to have it in electronic format myself. But I will say that, sometimes the other party will want a hard copy, and I'm not opposed to having that be part of the order for the evidentiary hearing. Again, it's much easier and better to discuss the issues earlier on.
Yep. Okay. All right. The hearing, presenting witnesses and evidence. All right, so obviously we talked about the importance of a joint stipulation of undisputed facts. That's going to make the process go a lot faster, and the arbitrator isn't going to have to wonder if the parties are in disagreement about something and have to question the parties on that. You should decide usually in advance whether fact witnesses are going to be examined by direct testimony, live, or by sworn statements. If you already have the sworn statements, it's probably going to be a quicker, more cost-effective process to move through the case, as opposed to actually having witnesses travel to the evidentiary hearing location, testify in person, et cetera, et cetera. With expert witnesses, you should consider hot tubbing. A lot of people say, what does hot tubbing mean with witnesses? In the old days, the witnesses would just kind of come individually one by one and offer their testimony and be cross-examined and whatnot. Now we're seeing a lot of witnesses kind of just together sitting at the table, being examined together, and their points kind of live right there. It can actually shave a couple of days off of an evidentiary hearing if everybody's kind of together. Um, Using a witness's depot for submitting depot experts for impeachment. Um, this is a great way to get your certain people impeached, right? Based on just what they've already written. And again, you're going to want to have those depot experts, depot excerpts, as exhibits and ready to go, either in a trial binder when or some other form. Sometimes if a hearing is going to be held virtually, there are some of these um, depot companies that also host virtual hearings for arbitrations where they can automate exhibits and all that kind of stuff and have it very easy to find and present. And then the issue of arbitrator questioning of witnesses, and I'll ask David in just a second what his preference is. There are some arbitrators that will never directly question a witness. They will ask their questions to counsel, and if counsel wants to relay that question to the witness, they'll listen to the witness's statement after counsel's question to them. It is usually faster and more efficient to allow the arbitrator to question the witness directly. I don't see an issue with that. David, do you have anything you want to add to this or a preference?
Yeah, I do think that's right. Although I'll say my practice generally is to allow for the party putting on the witness to question, have that initial cross-examination, and then for me to bring up any questions, because that way both sides have had a chance to ask it in their own way, and I'm not stepping into the process too
Sure.
much. But at that point, if I still have a question, quite frankly, it's going to be faster and easier for me to ask those questions, get to that point, and then provide a follow-up opportunity for redirect and further cross-examination uh, to clean up anything that I may have raised during my
So,
questioning. But
so David's
I don't want to take the initial step.
so your preference is after cross and before redirect. That's when you want to ask your
Correct.
questions.
That's the sweet spot for when I do have questions. I'll find that during direct I will be taking notes and I'll have kind of a running list of questions. And I'm, very grateful when that list of questions gets crossed off throughout the cross-examination process because it means, I counsel's already done the job there. If there's something that's still that needs to be addressed, I will. Sometimes it'll be about jurisdictional questions, for example, things of that nature,
Yep.
that are more procedural in nature than about the facts of the substantive case. But to the extent we need to, we will visit those issues. But I like to be in that middle part so that everybody has an opportunity before and after.
Managing exhibits. So we always say whether the hearing is remote or live, be sure all exhibits are legible and manageable for the arbitrator both during and after the hearing. There's nothing more frustrating than fumbling around for exhibits so you can't find where something is in a trial binder or something was put out of place if the exhibits are going to somehow be automated electronically. Um, Joint or separate exhibits, obviously, joint exhibits are going to be a lot more efficient. I know sometimes parties really can't agree to how they want to put their exhibits together, so it's kind of hard to get them to agree to this, but you should always shoot for joint. And then obviously considering the wholesale admission of exhibits as opposed to trying to introduce each exhibit individually and setting the foundation for it and whatnot and all this the normal trial practice stuff you have to go through. I mean, if you've ever been to an actual hearing in court or trial in court and seen how long this process takes, it can take just as long in arbitration, and you want to avoid that. David, do you have anything to add to that?
No, I think, I mean, the same points I've been hammering on. To the extent you can agree. To the extent that you can't, that's fine. But as long as it's in an organized fashion, we can move quickly through the matters. If there's questions about the exhibits, we can move through those quickly before or at the beginning of the evidentiary hearing. But it just has to be sorted out.
All right, we're in our last 10 minutes here.
Yeah.
Closing arguments and issues of interest, costs, and attorney's fees. So obviously, your closing argument is an opportunity for a summary, not a restatement, right? So we're not re-arguing everything you should have argued actually during the evidentiary hearing. You're kind of summarizing the strong points of your case. Focus on the elements and the evidence towards those elements. Common sense. Post-evidentiary hearing briefing, you're going to want to focus on helping the arbitrator think about and then draft the final award. And David was helping me draft this slide. The more you can get the arbitrator into that mindset of kind of what the final award would look like drafted in their head, the faster the process is going to be for David to draft the award. And make your
Exactly.
arbitrator or arbitrator's life easy by being clear and to the point, right? David's going to set page limits on post-hearing briefing and kind of tell you what he wants to see in the briefs. But
Mhm.
really, pay attention to that when he's giving post-hearing briefing instructions, whether he's giving it live, during the final day of the evidentiary hearing, or he's issuing an actual statement, a written statement explaining what he's looking for after. Attorney fee applications. All right. If the arbitration agreement is not explicit, then you'll need to, one, both brief the right to attorney's fees and costs, and two, the actual attorney's fees and costs. A lot of people, some states don't actually have statutes that surround the right to recoup attorney's fees and costs in
Mhm.
arbitration. A lot of states, it's just case law that's kind of floating around out there. Again, if this was explained in the arbitration provision, in a well-drafted arbitration provision, you wouldn't have to do all this extra briefing on whether or not you have the right to attorney's fees or costs, but you want to make it as clear for the arbitrator as possible. Um, and then when briefing the attorney's fees and costs, you want to itemize as much as possible. A lack of itemization may result in not being awarded your full fees and costs. Um, sometimes I've seen block billing when attorneys are issuing like their hours and things like that, or they'll just say kind of like a rough estimate of how many hours they spend on part of a process. You're not giving that kind of estimate back to your clients, you're actually sending your clients invoices with the exact number of hours you spend on certain tasks, right? So you want to be as detailed with that with your attorney fee application. David, do you have anything to add to that?
Yeah, I'll just say, I mean, I've had that situation, unfortunately, where there was insufficient detail, and so I suspect lesser awards were provided than would have been provided had further detail been provided. You obviously ask for follow-up and ask for that further detail. Sometimes it's forthcoming, and that's great. Sometimes it's not, and that's unfortunate.
Right. All right. Once the arbitrator has closed the hearings, the rules, at least at AAA, is the arbitrator has 30 days to issue the final award. Um, and essentially, what does the closing of hearings mean? It means that any direct exchange with the arbitrator is essentially ended. Most arbitrations at AAA are what we call direct exchange arbitrations, where the parties have permission from the arbitrator to communicate directly with the arbitrator throughout the process. So whether it's I need permission to file leave to file a motion of some sort, or I have a question, or we're planning on filing an MSJ. I need some guidelines from you on the process. Essentially, one party can email the arbitrator their communication, and as long as they're CCing all of the other parties in that communication, as well as the AAA staff, that's not considered ex parte communication. A small percentage of cases do not use direct exchange. These tend to be cases where, in a large complex case, the parties have basically demonstrated to the arbitrator that they lack the civility to use direct exchange to communicate with the arbitrator. They're usually very much at each other's throats. They are just firing off emails at the arbitrator off the cuff at 1 o'clock in the morning, on a Saturday, for no reason, to just to get the other side angry, right? And the other side's going to respond an hour later at 2 o'clock in the morning on a Saturday night because they're apparently people don't sleep, right? Um, things like there those limited situations where direct exchange is not used. In that situation, all communication from the parties has to go through the case manager, and the case manager will relay communications to the arbitrator. Um, so if once the hearings have been closed, then essentially all the communications have to go through the case manager. Now, something to remember is sometimes the arbitrator may choose to issue an interim award and not a final award. And just because an interim award has been issued, that doesn't mean the hearings have been closed. So what is an interim award? Well, an interim award is typically the arbitrator has made a determination who has won the arbitration, who has lost, and just what the winning side is entitled to. But the arbitrator would like further briefing from the prevailing party on attorney's fees and costs if they believe that they're entitled to those. And then they have to give the respondent the opportunity to challenge whether the arbitrator has the authority to award any attorney's fees and costs. And if the arbitrator does have that authority to question what's been submitted as far as the legitimacy of those charges. Um, and so just because an interim award has been issued doesn't mean necessarily the hearings have been closed, because oftentimes the parties are still communicating directly with the arbitrator between the interim award and the final award. Occasionally, once an arbitration award is issued, a mistake has been issued in the final award. Now, once the final award is sent, the arbitration is essentially over. The parties can no longer communicate with the arbitrator about the award. If they had any questions, they would have to go through the case manager. Now, we have a commercial rule R52 that basically says within 20 days of a final award being issued, any party upon notice to the other parties can request through the AAA that the arbitrator correct any clerical, typographical, or computational errors in the award. Now, notice I didn't say re-argue the merits of the case or point out to the arbitrator that they might have failed to rule on one of the 27 different causes of action or something that you're trying to go after damages on. This is
Well,
yeah, go
let
ahead.
me say this, Aaron. If there's something where there's a failure to rule on a cause of action, that is something that I think is legitimate. But to your point, it's not about re-arguing, no, you got it wrong, arbitrator, and here's why, right? This is really about the technical error not
You
about
you you
the
you you
substantive
put
error.
a decimal in the wrong place.
Right.
Right? Or you agreed with the parties that the interest rate that would apply to claimant's award was 5% per annum, and instead of 5%, you accidentally, when you were drafting the award, typed in 6% into the calculator, and one side's like you gave them too
Yes.
much interest. Things like that.
Yes.
And to David's point about missing a cause of action or something like that, all of our awards have a closing statement that basically addresses this. It says, this shall satisfy all causes of action basically brought before the arbitrator. And in the event the arbitrator actually missed one of those causes of action, well, that's covered in that catch-all sentence there at the end where, maybe the arbitrator made a mistake. Maybe they should have
Mhm.
addressed that, but that sentence prevents them from reopening that causes of action and having to reopen the case. I would say the majority of parties do comply with the parameters of Rule 52 and submit things that can be reviewed, but sometimes they don't. And the other side has the ability to issue a response to any R52 request. So if the claimant is claiming that David applied the wrong interest rate and they're due a little bit more interest, the respondent gets a certain amount of time to argue that David applied the right amount of interest and the claimants don't get that amount before he makes a decision. And lastly, I'd like to point out that the joint drafting of a model final award after interim award is issued is one of the best ways to avoid an R52 motion. If both parties have after the interim award is issued, work on drafting a final award themselves and simply ask for the arbitrator's signature, then if there's some mistake in the final award,
Mhm.
it's on the parties, right? It's not on the arbitrator because they're the ones that essentially submitted this product for the arbitrator's signature. All right, I know we're a little bit over and I'll just spend another minute or two. I'm not going to read through this entire slide here, but this is video hearings in the time of COVID and beyond, and these are just basically best practices for video hearings and in-person hearings, and also kind of a checklist of whether it makes sense to proceed with something in person via or proceed with something via video hearing. I hope we never have another situation with COVID where we can't do in-person evidentiary hearings because of some disease or condition floating around that one might catch. But if some other disease other than COVID comes or it somehow mutates and we all get shut down again, these are good rules to kind of follow as far as proceeding. All right. I've included our email addresses here. If you want to reach out to either one of us, we love answering questions. I am going to, I guess, stop sharing and then see if we have any questions in the box. I'll give folks a minute or two if they want to take a picture with their cell phone of our email addresses or anything like that to get them down. But I will now stop sharing. And let's see. Okay, Q&A. Okay, what are AAA statistics what are AAA statistics on MSJs less than 1 in 10 commercial arbitration cases? So I guess Jack is asking how many uh, MSJs are granted. Off the top of my
Mm.
head, I don't have those statistics, Jack. But David, in your experience, how many times and what percentage of your cases would you say an MSJ has even filed?
I mean, there's definitely a fair number of motions to dismiss. That's usually the nature that the dispositive motions take. I would say MSJs are probably in about 10% of the cases. Um, that being said, they are, in my experience, I'd say more successful than not, maybe about 2 to 1 but again, in that smaller number of cases. And I think that's because I'm going to try to discourage the extra time and effort of an MSJ if there's not a pathway. Sometimes people will feel obligated to file an MSJ. Just it's an opportunity to present your case in briefing to the judge or arbitrator. Um, I don't take that view, but yeah, that would be what I've seen.
Yeah.
And that may just be the types of cases that come before me, but it's not incredibly common in arbitration.
Another good question from Jack is low-cost desk arbitration ever allowed in small disputes under $100,000 in commercial arbitration cases? Um, so um, the parties can certainly agree to using desk arbitration, basically where an
Hmm.
arbitration is just heard on the papers without actually any live testimony. We have desk arbitration written into a couple of our rule sets for smaller
Hmm.
consumer disputes, as well as our construction fast track cases, which are construction defect cases, usually residential construction with
Hmm.
claims under $100,000. So if the parties would like to do desk arbitration for smaller disputes, and it's outside one of our rule sets that actually calls for desk arbitration to resolve the dispute, the parties are always agreed can always agree to that. Does AAA ever allow smartphone recording and um, no cost automation of transcript generation via AI technology? So, um, David, so do you allow the parties on their own to record any of your hearing or the process? If the parties
I don't believe I've encountered a cell phone recording. I have had parties want to use the transcription features of video conferencing
yeah,
software.
right,
I do think that's something that has to be addressed. Is something that I will talk about either in that preliminary management hearing or in the pre-evidentiary hearing status conference. Just because it is making a recording,
yeah.
right, of what's going on. But I have allowed it. I'm open to it. I'm open to the use of the technology. I haven't had a request to use a cell phone or a smartphone or something like that to kind of, I guess, set it
Yeah.
up on the side and record the screen, something like
And,
that. But
and I'll just add to
yeah,
that, especially the transcript generation via AI technology. I think what the question is pointing out there's all these different transcription tools you can basically have like almost like an AI bot on your Zoom transcribing kind of what's being
yeah,
said and all that kind of
yeah.
stuff.
And
But
within
we
Zoom itself, I believe.
but we do partner with an organization, a depot company called Optima Juris that has a virtual court reporter, which
Hmm.
is a tiny fraction of the cost of an in-person live court reporter that some parties use to transcribe the evidentiary hearing and sometimes even
Yeah,
motion hearings, that basically listens to the parties' voices, comes up with a rough transcript, and then a human being on the back end kind of cleans the transcript up. But again, it uses AI technology and it's a lot less um, expensive than a traditional
right.
in-person court reporter.
So let me just say this, that what I do point out when I allow for those kinds of things is I also point out, depending on what you're using, if you're using the transcription, you're using some kind of bot that joins the meeting type thing, or you're using a middle range product where there's AI and then a human going through doing some editing versus a full-blown court reporter in a traditional sense,
Yeah,
those various levels are going to have various levels of reliability. And if there's a distinction or an issue that comes up, that's going to be taken into account later on if we have to go back and try and rely upon the auto-generated transcript and there's a word that's going to make a
yeah,
difference to an element of the case.
yeah.
But the parties, as long as they're aware of that and understand that, I feel like that's their choice to make. They
Just
just have
wanted
to
to get to
make the
these
reasonable
last two
choice.
questions quickly because I know we've run over
Yeah,
here. How
yeah.
common is the grant of attorney's fees and costs, and what is the most important consideration in awarding? So, I would say the most important consideration in awarding is if it properly explains what David's authority is in the arbitration provision. But David, whether you've seen your authority granted in the arbitration provision or it's silent, how common is the awarding of attorney's fees and costs, and what are your most important determinations?
That's a good question. I don't even necessarily know offhand. I would say it's less than maybe I'd say probably under 20% of arbitrations where it's been awarded. But that also, the problem is it's not always something that is granted. I don't have the authority
Right.
oftentimes. And if I don't have the authority, well, then obviously it's out. So I can't give you a good estimate. Out of those cases where I have the authority and it's granted, I can't give you a good number on that.
And it's important to mention that David handles cases here at AAA all the way from some of the smallest consumer disputes all the way up to large complex cases under our LCC rule set. So
Yeah.
it's more common, I would say, the awarding of attorney's fees and costs in the larger in the large complex case tracks,
Right.
at that level, especially where the parties might be spending hundreds of thousands of dollars or millions of dollars on attorney's fees
Mhm.
and arbitration costs in a really big case.
And I think that's a function of those larger cases are going to have more complex contracts involved where it's an issue that is addressed.
All right, David, last question here. How are CCP 998 offers in compromise handled? Is there a AAA rule of practice in California, and how's this handled?
Yeah, so 988 offers do not automatically translate over to AAA. It's civil procedure unless there's a provision in the arbitration clause that specifically is going to be applying California procedural law.
Correct.
I haven't encountered that situation myself, but I do think the principles behind it stand in that it really at its core, what 998 is encouraging is settlement discussions and mediation. And as Aaron went over, AAA does that through a number of other vehicles.
And just to really summarize that, the reason AAA doesn't have a California specific rule to address that is our rules are drafted for a national audience.
Right.
Many states do not have the equivalent of a California 998 offer rule, so it wouldn't make any sense for us to add something like that into our rule books, especially when they're being used for all 50 states and territories. Okay,
Yeah.
without further ado, that's the final question. Thank you all for joining our presentation today, and we'll see you next time. Bye.
Yeah. Thanks everyone for your time. Thanks, Aaron.